Birnhack.
Thank you so much. So I will be focusing on digital issues rather than the ancient stuff. And in fact, my talk this morning is just a footnote to Sheila's talk. So thank you once again for having me here. And following on Sheila's discussion, I would like to discuss some of the challenges that democracies face in the context of the digital environment. And yes, there will be some more Mark Zuckerberg in my slides too. I will not be as eloquent or funny as Sacha Baron Cohen. If you haven't seen his talk at the ADL last month, you should. It's a brilliant talk. It's quite obvious that a few technology giants have gained enormous power to the extent that they threaten our democracy and enhance some of its deficiencies. These are private, commercial entities, and if you're not American, they are also foreign entities. The same companies, however, also offer us new services that at the same time enhance our democracy and enhance some important features of democracy, mostly the conversational sphere, the public sphere, speech, etc. So if we can adopt one of Facebook's relationship statuses, it's complicated. So there are numerous issues here, and I wish to discuss a few of them by pointing, only a few of them, by pointing to a few non-exhaustive list, a few challenges here. First, there's a tension between the social interest in maintaining the well-functioning of democracy on the one hand, and the legitimate commercial interest of companies, platforms, to act and thrive in this environment on the other hand. And of course, we as a public, we also have an interest that they can operate in a free market and a competitive market, etc. Second is the tension between the local and the global. And third is a challenge of which I call participation and identification, which I hope will be clearer later on. So once again, this is not a neat separation. These questions are intertwined, and of course, there are additional layers and issues and questions here. I would like to begin with a few examples just to illustrate what is going on here. So, in September 2016, a few years ago, a Norwegian writer posted on Facebook a story under the title, 7 Photographs That Changed the History of Warfare. And, of course, he added for illustration this extremely famous photo. It was taken by Nick Ut in 1972, and the girl pictured there, her name is Kim Phuc. She now lives in Canada. Then, at the time, she was a 9-year-old girl in Vietnam, running away from her village, just bombarded by the American forces with napalm. Facebook removed the photo, saying that while we recognize this photo as iconic, it's difficult to create a distinction between allowing a photograph of a nude child in one instance and not others. So, as far as Facebook was concerned, this is child pornography, right? Because there's a nude 9-year-old girl there. Following a global protest, Facebook reversed its decision, and now it explained that an image of a naked child would normally be presented to violate our community standards. Remember this term, community standards. And in some countries might even qualify it as child pornography. In this case, we recognize the history and global importance of the image in documenting a particular moment in time. Thank you very much, Mr. Zuckerberg. What does this mean? Okay. We have a photo which in this context is a matter of speech, political speech, hence freedom of expression, posted, and this was posted by someone who wanted to express a certain view. It was taken down by Facebook. Why? Because it runs against Facebook's rules of what it calls in an Orwellian newspeak community standards. Facebook wishes to block child pornography, which is fine, but obviously it has some misjudgments here. How does Facebook make its decisions? How did it decide to remove that photo and then put it back again? Well, we do not know how Facebook really makes its decisions about this. It has rules, presumably, which it does not explain. It may have been a decision made by a human being, and Facebook does employ quite a few thousand people, mostly in the Philippines and in India, that are content moderators. How did the person in the Philippines or India or wherever he or she was situated, how did they make the decision to remove the photo, the first decision? They're exposed, these content moderators as they're called, they're exposed to tons of unpleasant material, really unpleasant material. They have to act fast, really fast. They do not have a tidy adversarial sort of legal argument. They don't have a court hearing there. They are underpaid. Do they have a checklist? We do not know. Maybe that checklist, if such exists, says no nudity. Do they have discretion at all? Perhaps the checklist says no naked children. Don't allow that. Do they have discretion? I ask once again. If they do, so the person who made the decision to remove the photo in the first place obviously had no clue about the meaning, the context, the importance of that extremely famous photo. The decision might have been made by an algorithm. It might not have been a human being who clicked the delete button, but an algorithm which automatically recognized nudity and a child and decided to remove the content. Algorithms do not operate out of thin air. They are taught, they are designed by human beings, they are fed. This is the process of machine learning. Machines are not always fine-tuned to know the context, and this case illustrates the failure of the AI decision if it were an AI rather than a human being decision. In other words, Facebook made a decision about what is excluded from the discourse based on the content and according to vague and overbroad standards, which are not transparent, unexplainable, either ex ante or ex post. Had it been a governmental decision, it would immediately fail any First Amendment in the US, but also presumably in many other democracies. It would have failed judicial scrutiny at the outset. So, this is Mr. Zuckerberg in one of his famous statements, okay? Move fast and break things. And indeed, when you move fast, things are broken by you, by him. Facebook made a decision, okay, so as mentioned, this particular issue of that photo of the Vietnamese girl running away, that particular issue was solved after the users protested. But how many other photographs and texts and other kinds of content are removed without making the headlines? We do not know what we do not know, and Facebook does not share such information. An important segment of the public discourse is governed by a private entity which is not accountable to the people using it, also known as consumers or clients, or in the data context, data subjects. Thus, from this case, we learn that by using Facebook, we, as a collective, have outsourced an important segment of the public discourse to a private, commercial, and in many cases, foreign to us entity. A second case. As you know, we had elections, and then we had another cycle of elections, and now we are about to have another cycle of elections. Interesting things are happening here. During one of the previous two, the first one, I think, election cycles, Justice Meltzer, that's Justice Meltzer for those who are unfamiliar with him, he chaired the General Election Committee, and he issued an important decision regarding anonymous political speech. During the campaign, large billboards, whoops, not this one. Oh yeah, the large billboards. That's a billboard carrying photos of 4 prominent Israeli journalists. Those are well-known Israeli journalists, with the headline "They will not decide." The ads did not indicate who published them. They were anonymous. However, an investigative journalist found out that one of the parties, the Likud, was behind this billboard. The Propaganda Law, well, this is how it's called over here, the Propaganda Act requires that political ads carry the name of the party that commissioned it. Justice Meltzer ruled that this rule applies to the online political ads as well, including on social media, at least for the duration of their campaign. Not before and not after, but for the duration of the campaign. Justice Meltzer, in his decision, did not discuss the costs of limiting anonymous speech. But he did mention that identifiability can help the security forces prevent foreign interference. This is a hint at the Russian interference or allegations of Russian interferences in the 2016 American elections and the Brexit campaign and presumably other places. So the idea was that if the ads are anonymous, that might be a foreign government behind them. Hence, it's important that political ads are identified and not anonymous. Framed in a broader framework, in broader terms, the challenge here is one of participation and identification. In some cases, anonymity is needed to enable participation. This was true of the authors of the Federalist Papers more than 200 years ago. That was true of Mary Ann Evans, who had to disguise her feminine identity as a poet and use a male nickname, George Eliot. It is true of minorities, especially minorities within their own community. For example, it can be a right-wing person in Israel living in a leftist kind of kibbutz. It can be a leftist living in a settlement in the West Bank. It can be a person who has lost faith but still lives in her or his closed religious community. For them, anonymity is the only way they can express their views and participate in the political discourse. So anonymity can be, doesn't have to be, but it can be a key to participation. It can also be a key to political manipulation, that's true. As Justice Meltzer commented, identifiability is needed to protect the political system and its integrity from external interferences. Technology could do some of the work here. IP-based identification, Internet Protocol-based identification, could assist in identifying the people. So here's a bit about IP identification. 20 years ago, a bit more, Yahoo offered a sales platform similar to the way more successful eBay platform that we know now. It enabled users to buy and sell items between themselves. Yahoo just provided the platform for doing so. So Yahoo was the market, but it did not interfere with the sales themselves. A French court then demanded, following a petition, that Yahoo disables the sales of Nazi memorabilia. These were items that were offered for sale, bought and sold by users on Yahoo's platform. And the French court ordered Yahoo to disable this because it contradicted a French law which prohibits hate speech, and buying and selling Nazi memorabilia was and still is considered to be a form of hate speech. Yahoo resisted and said that it cannot do that. Well, that was just simply wrong and false. Yahoo could and did eventually identify users based on their IP. They could easily say, oh, this is a user who originates from Paris or some other French territory, if you wish. But Yahoo has also argued that it's an American company. And under the First Amendment, Yahoo, is fine with not interfering. In fact, a hate speech law, they argued, probably correctly, would have been unconstitutional in the United States under the First Amendment. So we have a global and local case here. Another case, which Sheila has mentioned before, is the so-called right to be forgotten. It all emerged in this tiny bit of notice in a Spanish newspaper, which was then digitized and made available online. The European Court of Justice acknowledged the right to be forgotten, which is more accurately the right to be de-linked or de-referenced, meaning that Google has to remove the link, but the newspaper can keep the original online. The European Court ordered that when searching for a person according to his or her name, some results, those that are no longer relevant, can and should be removed upon request. So the original publication remains on the website, but the link is then removed. The GDPR, the General Data Protection Regulation, now has anchored this right as part of the law, so it's not only judicially made, it's part of the legislation. Who makes the decision about the removal of content? Can I search myself on Google, and if I don't like one or two of the results, can I ask Google to remove that? Well, I can, but Google will not listen to me because I'm not European. Okay? Currently, they apply the right to be forgotten only in the EU. But who makes the decisions? When a European citizen approaches Google and asks for a certain link to be removed. Well, once again, it's a private commercial company, and Google does not really say how it makes its decisions about this. It does give examples, but these examples do not explain that much. We have to decipher the examples and figure out what is Google's law about what is going on here. Okay, there's some more about a recent case that was decided in the summer by the European Court, but I will skip that to save some time for other things. The question here, having this being applied only in the EU, is once again, and building on the French Yahoo case, a tension between different legal systems. Should we adopt a global standard, which is in fact an American standard, or should we adopt a local standard, hate speech laws in France or First Amendment in Europe, which should apply to the online sphere? One of the promises of the Internet, as it emerged in the 90s, was that it was global. This is also John Perry Barlow's sort of sentiment in 1996. Or as John Lennon asked or suggested, imagine there's no countries, imagine all the people sharing all the world. But that dream did not come true. Governments of the world do impose their local laws on the virtual space. This is the case with China, which was mentioned earlier, and its great digital wall. This is the case with France and its law on hate speech. This is the case with Germany and its Network Enforcement Act. It has some long German name, which I cannot pronounce. Or Israel, with its decision regarding anonymous political speech. But it is also the case with the data giants. They are incorporated in the United States, and they wish to carry their laws, American laws, in their kit bag wherever they go. The lesson from this case is that as a matter of current law, a state can impose its laws onto the global foreign commercial parties, but that these entities may decide not to obey. And they do so in some cases when they just dislike the local order. The cost of not obeying just may be minimal for them. They may be fined, but they don't really care about that in most cases. The local has its say, but the global is often more powerful, and the global is technological. In the last few minutes, I would like to discuss another issue, and that is the much discussed fake news. There's a lot of fake news online. Some of it is just, simply mistakes made by whoever posts whatever content. But of course, fake news can be deliberate. It may be spread by internal political players, from just a member of the opposition, up to the president. Or it can be spread by external players, eager to interfere with other countries' politics in a covert manner. We are all familiar with the claims about the Russian interference in 2016 and in Brexit later on, etc. The platforms, Facebook, Google, etc., at least in the US, enjoy full, complete immunity. This is Section 230 of the CDA for the lawyers among us. ISPs, platforms in the US can do basically whatever they want. They can interfere in the content and they can decide not to interfere in the content. Whatever they do, whether they interfere or not, and if they interfere according to their rules, whatever they do, they are immune. They are immune from both those who might be harmed and from those whose speech was removed or edited, etc. This is the idea of the extremely powerful and influential Section 230, which the subtitle, by the way, is The Good Samaritan. Okay, the idea is to encourage the platforms to interfere, and if they cause harm in that process, they do not bear any liability. But the result was that many of the platforms said, okay, we have immunity, we can interfere and assist, but we can also do nothing if we so wish, and many of them do not do anything to moderate the content. The platforms, Facebook once again, they say that they are for speech. Why not? That is, they also say that it's for the user to decide for himself or herself what is correct and what is not. So it's user empowerment now spoken to us by Mr. Zuckerberg. Facebook and the others, they say, well, we are not arbitrators of truth. Well, of course, it would have been very expensive for them to try and become arbitrators of truth. Frankly, I simply think that, you know, the Hagolem Gavar al Yotzo, the beast has grown and is just too big. I don't think they managed to control Facebook, etc. What they have created themselves. What does Facebook do, or at least say it does? It says it uses fact-checking companies, something that journalists used to do in the old media. Facebook says that it develops algorithms that can tell truth from lie. That will be interesting. I wonder what John Stuart Mill would have thought about such algorithms. But they say, ultimately, it's the user who should make the decision. Facebook further says that, or announced, that it will not touch political ads even if they are clearly false. And they were challenged. So Elizabeth Warren is here too. Twitter announced recently that it will not carry any political ads, which it is allowed to do, to not carry any political ads whatsoever. The issue of fake news and what should the platforms do is a tough case. It's not easy. If there are new platforms to spread truth, we want them. We want to have these platforms. This enhances speech opportunities, participation, and access. It enriches the discourse, the marketplace of ideas. Facebook indeed would be a terrible decision maker, and we've seen some example of that. Elizabeth Warren and Alexandria Ocasio-Cortez, as they pointed out, Facebook would also publish obvious lies. Sacha Baron Cohen, in the talk that I mentioned earlier, he argued that today Facebook would probably publish Goebbels and Holocaust denial as well. And he's probably right in that Facebook would not interfere and say, oh, it's for the user to decide. There are different issues here, of course, as there are facts and opinions, some easy to challenge, some more difficult to challenge. Media studies scholar Siva Vaidyanathan says that Zuckerberg is simply uneducated in the deep sense of not being educated. I think this is a generous statement. A less generous one would say that Zuckerberg acts maliciously, in that he is uninterested in the well-functioning of democracy, and he is interested only in one thing, and that is his company's good. And as we know, Facebook is Zuckerberg, and Zuckerberg is Facebook. There are many more issues and stories and examples, and the picture only becomes more complicated than a few minutes ago when we started this discussion. So here are some overall themes that emerge. We have more speech opportunities than ever before, and that is wonderful, and this is a cause for celebration. But the gatekeepers are no longer public bodies. It's not court or legislatures. The gatekeepers are private, for-profit, often foreign players who are unaccountable and are not transparent. The decision-making has moved from legislators and judges to corporate rooms and to black box algorithms. The law can attempt to extend its reach, as with Justice Meltzer's decision or the French Data Protection Agency CNIL decision, which I skipped earlier. But this is only a fraction of the discourse. To a large extent, we are left to our own devices. We are left to distinguish between true and false, to make our minds about anonymous speech, and to remain independent. This is tough on a daily basis. It's very tough. We are busy. Our attention span is short. We are overwhelmed by information. And those who try to manipulate us, well, they are typically way more sophisticated than us. Social media has too much power here, but limiting its power, but limiting it would be only part of the picture. There's still a long road ahead. And this is a photo of an ice road in Estonia, which melts in the summer. Okay, it operates only in the winter. This was the subject of the Delphi case decided by the European Court of Human Rights on the liability of ISPs to negative content published online. So is the road ahead just an ice road which will melt soon? Thank you so much.
We have 4 minutes for discussion.
4 minutes.
So I'll ask a question.
Sure.
You've mentioned Google, Facebook, but there is a matter of interaction with political leadership. I've been researching racism for decades, and it is now clearly the case that in some countries, some nearby, others far away, political leaders actually encourage racism. Is this problem being reinforced by the subject you discussed, or is it no different from what it was in the 1930s?
Well, you know, racism, it's a global and local issue, right? So once again, the technology companies, the platforms, they are global, and in different jurisdictions there are different laws about racism, whether people can say things or not. In the United States, well, you know, under the First Amendment, people can be racist as long as it does not lead to, you know, people acting. So there's no incitement. In Israel, in France, in Germany, and presumably in many other countries, there are laws against racism. So what we see is that some countries try to apply their local laws onto sort of, you know, a segment of the virtual space, kind of France, the French virtual domain, which, you know, and they do so, whereas in other places that is not the case. And this runs, you know, against the original idea of the internet as a global technology which would connect people and the world will be as one and all of those nice ideas. We do have, you know, now a French internet and an Israeli internet and an American internet and a Dutch internet. And as Sheila mentioned earlier, when we travel, many of us, and we access the internet, you know, it's different. Not only an additional heading about cookies or something like that, the content is different. In class, I teach an international group of students, and typically there's a student from China, and I ask everybody to use a VPN, a virtual privacy network, and connect online to Google, or Baidu in the Chinese case, the Chinese search engine, as if they were in their home countries, and then we all search something such as Tiananmen. And we just, you know, ask the students to turn around their computers so that we can all see the results. And the results are very different, okay? In the way that things are presented, what shows up, and how it is showed up, how it is presented. So the same with racism. There was I did not mention that, but as you know, there's a huge debate which has been going on forever about who is a Jew, right? Neo-Yehudi. And that is important for religious issues and for governmental, administrative issues, with numerous cases in the Israeli Supreme Court over the years. Today, the issue is decided by Google. think about a Swedish school girl who studies about different religions in the world, and she is given some homework, you know, to study about Judaism, and she knows very little about it. How do students prepare their homework today? Well, they go to Google and Wikipedia, right? But if you Google Jew, or if you Googled Jew, if you Google Jew on Google.com, kind of the global American version, typically the second result will be an anti-Semitic website. If you Google that in Germany or France, and today in Israel, you don't get any anti-Semitic sites because those are removed because of anti-hate speech laws. At some point, if you Google after complaints, if you Googled it on Google.com, a notice showed up which says, we terribly regret, not exactly wording, but the spirit, we terribly regret that you encounter unpleasant results. If you're interested in Judaism, here's a recommended link. Yeah. However, we do not interfere with the content because we are neutral and objective and free speech and First Amendment, ta-da-ta. And then you would get the anti-Semitic website. So,
thanks very much.
Thank you.